Get ready for breaking news. The Central Information Commission has delivered a massive ruling today, declaring that the Board of Control for Cricket in India, the BCCI, does not fall under the purview of the Right to Information Act. This is huge news for transparency in Indian sports governance, and we are diving deep into exactly why this decision was made and what it means for the future of cricket. Simply performing a public function does not automatically grant it RTI protection. We break down the legal arguments that led to this significant change. And finally, we look at the broader implications of this ruling. Discover how this decision impacts transparency in the IPL governance and what this means for future accountability in Indian sports. Don't miss this essential analysis, stick with us, and hit that subscribe button for more breaking news. The Central Information Commission has ruled that the Board of Control for Cricket in India, or BCCI, does not fall under the purview of the Right to Information Act. The Commission reversed a 2018 order by the then CIC Commissioner M. Sridhar Acharyulu, which had classified the BCCI as a public authority under Section 2(h) of the Act. The decision followed a petition filed seeking access to information regarding the BCCI's operations and affairs. The CIC concluded that the BCCI is a private organization whose objectives are to promote cricket, and its functions are governed by its internal rules and regulations, independent of any statute, and are solely related to its members. BCCI had contested this ruling in the Madras High Court, asserting its status as an autonomous organization and arguing that the lack of substantial government funding exempted it from RTI jurisdiction. The High Court referred the matter to the CIC for a final verdict. The ruling specifically addressed arguments that the BCCI performs public duties, such as selecting the national cricket team and representing Team India. The Commission dismissed the contention that public duties can serve as a deciding factor for information disclosure. Furthermore, the CIC clarified that while the BCCI may hold a monopoly over cricket in India, this fact is legally irrelevant for determining a public authority under Section 2(h) of the RTI Act, as the Act does not include public function as a criterion for this determination. This verdict highlights an ongoing legal conflict regarding the BCCI's roles and its legal standing under the RTI framework. The Central Information Commission, CIC, has reversed its earlier decision regarding the Board of Control for Cricket in India, BCCI, ruling that the organization does not qualify as a public authority under the Right to Information, RTI Act. The Commission stated that the BCCI is neither owned, controlled, nor substantially funded by the government. The reversal follows a recent appeal where an individual sought information concerning the provisions and authority under which the BCCI represents Indian players for national and international cricket tournaments. The CIC observed that the BCCI is a private autonomous organization registered under the Tamil Nadu Societies Registration Act and was not established through constitutional provisions, parliamentary acts, state legislature, or any government notification. The Commission noted that a Central Public Information Officer, CPIO, from the Ministry of Youth Affairs and Sports, in a letter dated December 14, 2017, had previously indicated that the requested information was unavailable and that the RTI application could not be transferred to the BCCI because it was not declared a public authority under the RTI Act, 2005, a position upheld by the First Appellate Authority, FAA. This decision overturns a ruling made 7 years ago, where the CIC had previously declared the BCCI to be a public authority, citing that players wear jerseys bearing the country's name and that the board receives some form of government support. The previous ruling emphasized that the BCCI must be accountable to the public. The BCCI challenged the CIC's earlier decision in court, arguing its status as an autonomous and private body. Subsequently, the Madras High Court sent the matter back to the CIC for reconsideration, taking into account previous Supreme Court judgments. The Central Information Commission has issued a significant reversal in its 2018 ruling, determining that the Board of Control for Cricket in India, BCCI, cannot be classified as a public authority under the Right to Information, RTI Act. This decision effectively clarifies the legal status of the Cricket Board concerning transparency mandates. The ruling came after the CIC dismissed an appeal seeking detailed information regarding the authority under which the BCCI represents India and selects players for national and international competitions. Information Commissioner P.R. Ramesh explained the rationale, stating that the BCCI operates as a private autonomous body, registered under the Tamil Nadu Society's Registration Act, and was not established by the Constitution, Parliament, state legislature, or any government notification. Consequently, he asserted that the provisions of the RTI Act are inapplicable to the BCCI in this specific context. This decision reverses the earlier 2018 stance, where the Commission had previously ruled that the BCCI should be treated as a public authority. Previously, Information Commissioner M. Sridhar Acharyalu had directed the Cricket Board to appoint public information officers and adhere to transparency rules, including proactive disclosure of information to the public. Following a challenge by the BCCI in the Madras High Court, the matter was sent back to the CIC for reconsideration. In its revised assessment, the Commission concluded that there is no government control over the BCCI's functions, finances, administration, management, and affairs, thus negating the status of a public authority. The CIC further clarified that merely performing a public function, like managing cricket in India, does not automatically subject the board to the RTI Act. While this ruling clarifies the BCCI's legal standing as a private entity, it is unlikely to cause immediate changes to the operation, scheduling, or rules of the Indian Premier League, IPL. The tournament is expected to continue under the BCCI without immediate alterations to franchises, players, broadcasting, or tournament regulations. However, the decision has implications for future discussions on transparency and accountability within the IPL ecosystem. As the BCCI is no longer mandated to disclose information via RTI requests, governance matters, financial decisions, team operations, and administrative processes may remain outside mandatory public scrutiny unless future legislation modifies this position. The Board of Control for Cricket in India, BCCI, has been clarified not to fall under the purview of the Right to Information, RTI Act. The Central Information Commission, CIC, issued an order on Monday confirming this stance, overturning a previous ruling by the Madras High Court. The core reasoning behind this clarification centers on the BCCI's status as an autonomous private body rather than a public authority established by law or substantially financed by the government. Information Commissioner P.R. Ramesh reversed the October 2018 order by M. Sridhar Acharyalu, asserting that the BCCI is a private association governed by its own rules. Ramesh stated there is no deep or pervasive government control over its administration, emphasizing that mere supervision or regulation by the state is insufficient to change its private character. Furthermore, the order noted that the government does not appoint the BCCI office bearers. Regarding financing, Ramesh clarified that the BCCI is financially self-sustaining, generating revenue independently through commercial activities such as media rights, sponsorships, and ticket sales. Consequently, it does not receive substantial financing from the state. The BCCI is registered under the Tamil Nadu Society's Registration Act, 1975, and is not governed by any specific statute. The order also detailed that the Indian Premier League, IPL, contributes significantly to the BCCI's income alongside media rights and sponsorships, highlighting that the organization's functioning is shaped by market forces and commercial dynamics rather than solely governmental oversight. This development comes after the union government had previously dropped plans to bring the BCCI under the RTI ambit. It is noted that amendments to the National Sports Governance Bill, 2025, stipulate that sports bodies receiving government funds will be subject to the RTI regime.